thank you all for being here today for another one of our coffee chats in our series that we've been having here at Thompson Hine. We are very pleased that you all can make it today. Well, first let me introduce myself. My name is Ernie Badway, and I'm a partner in the Business Litigation and Investment Management Practice Groups. And we are so happy for you to be here for our Securities Coffee Chats. We're trying to provide, sort of a concise, practical discussion on a bunch of hot topics and trends impacting the financial services industry. And there can be no hotter topic than the one that we're going to be talking about today. Our session today is called Navigating Choppy Waters, Broker-Dealers in the Shifting Regulatory Tide. We're going to be exploring key enforcement trends with our panel and regulatory priorities shaping the industry in 2025 and beyond. Our panelists will address the SEC's Reg BI enforcement, FINRA priorities, dual registration issues, and the dreaded fate of the PCAOB and what's going to happen there. I am pleased to introduce our amazing panel, my partners and colleagues, Mark Miner, who is a senior counsel in our investment management and business litigation practice groups, and Mark will be acting as today's moderator. Rich DeBerry, our business litigation partner who specializes in this area, as well as Brian Lancelot, another business litigation partner who also specializes in this area. We want and encourage all of you today to ask questions. That's what this is all about. We want to have an active forum, and you can submit your questions in the chat box throughout the program. We'll address as many as possible during the session, and we will follow up on any that we do not get to, and we always do. With that said, I'm going to hand it over to Mark to get us started. And Mark, let's roll.
Thanks very much, Ernie, for that introduction. So, with that, let's get going. In putting this program together, there were so many interesting topics that we could talk about. The group had wonderful ideas. We only have an hour, and so we try to whittle this down to some manageable list of really topical issues that our clients and the market are trying to get their hands around. Some people are asking questions about whether or not in the current administration that we're seeing any particular retreats or areas that regulators are jumping into, and what that all means for those who are involved in or interact with broker-dealer interests. So I'd like to start with the SEC's regulation best interest. Over the past few years, we've seen certain trends develop with respect to enforcement with Reg BI. Some rulemakings that were nascent, some that had passed and were just starting to be enforced in some meaningful ways. And now comes a new administration, and lots of questions that we get from our clients and the public are around what is happening in the current environment, how much an institution should be investing in the regulatory and compliance apparatus to make sure that they stay on the right side of regulatory attention, as I like to say. So why don't we start with this? Let's just talk about what are some of the common deficiencies that the SEC has identified recently in its enforcement actions. Brian, would you like to take the lead on that?
Yeah, thank you, Mark. I think, the first thing I want to do is sort of set aside, I think there's some legacy issues around sort of like junk bond issuances that, there's still enforcement decisions trickling out of that, but those don't really reflect the current, I would say, most common deficiencies. They certainly represent a problem around the care obligation, but they're not the main focus these days. What really seems to be getting more attention and is more interesting, and it's been ramping up, and I don't think that the change in administration, particularly, bespeaks, a slowing down, are the conflict of interest issues that affect dual registrants, in particular around commission splitting, being unclear about who is getting what commission, where the compensation is flowing, and how that gets communicated back to customers in terms of, meeting your disclosure obligations, or, on the other side of Reg BI, the actual conflict obligation themselves to mitigate or eliminate conflicts of interest, right? Where you have the broker's financial interest clearly out in front, and that just can't be, that's just not acceptable. So I think that's sort of the top of the list in my mind of what is trending and is not going to see a particular change with the current administration. I don't know if you guys feel differently or if you're seeing the same thing.
No, thanks, Brian. I just to jump in on that, I don't think that a change in administration is affecting, to keep that theme going, is affecting this analysis or this enforcement. And I think you hit the nail on the head in one critical respect, and that's disclosure and paper trail. If you're going to have a Reg BI analysis, whether it's a conflict of interest or just an objective analysis of what's in the best interest in the customer, even if you're collecting a fee, because this is financial services and you're providing services, that it be laid out in matrix style format. It costs this, the benefits are this, the characteristics of the investor are this, and the characteristics of the product are this, and here's why they're intersect, and it's in the customer's best interest to pursue this strategy. What I just described is a pretty fulsome analysis, and if you have a culture of compliance, that whether they're writing it down in box form, in matrix form, or just going through the analysis themselves, that's what you need to do for every decision, including basic decisions on, for example, and we'll talk later about dual registration, which account a client opens in the advisory side of things or in the broker-dealer side of things. Even that kind of nascent, fundamental threshold question deserves a Reg BI analysis, because different fees will be charged. Different things and different investment objectives for the same person may be achieved in either kind of account, and have a discussion, run the analysis, and document it so that every decision, not just making a trade or making a recommendation, but every decision, including that kind, shows you're thinking about conflicts, thinking about fees, and thinking about the characteristics of the investor, which is going to be something that we talk about a lot in the next 50 some odd minutes.
Right. I think it's interesting, Rich, that you mentioned the culture of compliance. Before we got on today, I took a spin through not SEC, but some FINRA actions. And just in the last 3 to 4 months, there have been, I think, more than a dozen that address the sort of the failures with the compliance obligation under Reg BI, both with respect to, discharging your reasonable basis analysis, but also with managing conflicts of interest. And this again, these compensation issues, the financial interests of the broker being out in front of the customers. So I think baking into, policies and procedures, training, et cetera, how the firm is going to address these things beyond just sort of being aware that Reg BI is out there and the firm has an obligation, but actually doing something with it, that has become, a much more fertile area for, enforcement action as well.
Yeah, it's one thing to know Reg BI. It's another thing to hold on to Reg BI.
Exactly.
Yeah, that's one interesting point about Reg BI. People think about the blocking and tackling to the extent that they have their hands around it, and they forget about the compliance part. And so if you look at the examination priorities that the SEC puts out every year, the past couple of years, there certainly has been mention of Reg BI. And so one of the things that we always are talking to our clients about and try to do is help absorb those types of enforcement actions that you're talking about, Brian, and making sure that your compliance apparatus, your written policies and procedures and practices are a living document, are incorporating the most recent cases that have been made to ensure that they are reasonably designed to prevent or detect of those types of problems. So of those conflicts of interests, I guess we're going to get a little into dual registration a little later, as Rich described. I'd say far and away the lowest hanging fruit that the regulators seem to be focused on is looking at your own policies and procedures, right? Have you implemented Reg BI, and are you doing what you said that you were going to do? Conflicts of interest are very often easily or more easily satisfied by some robust disclosure in the event that there is some relationship between a broker-dealer, investment advisor, or a source of a fee that could be a potential conflict. And so it seems very rudimentary, but just looking back at the policies and procedures that you have can go a long, long way. And certainly the enforcement actions could have been avoided had the rules that they set for themselves simply been followed, or the disclosures been more robust, and they may have been able to avoid some of that regulatory scrutiny. And so Reg BI is still very much on the radar screen, like Rich said, and more to come about that. So let's move on to another topic that seems to be on the lips of everybody in financial services and all the ways that it intersects with what they do. Let's talk a little bit about regulatory priorities, particularly FINRA's approach to priorities for retail communication and crypto asset securities. Rich, what are you finding there?
Sure, yeah, there's nothing more 2025 than retail and crypto. And these are really the new choppy waters, or whatever the motif we are going with this coffee chat is. This is really what's rocking those waters under the surface. But it's not under the surface. It's front and center. It's every time you turn on your apps. It's every time you turn on your financial services information source, or even commercials during the Super Bowl. In the last few years, the general public and retail, have been inundated with crypto and retail services communications, advertisements for communications. In FINRA's 2025 annual regulatory oversight report, which they released in February, unsurprisingly, they dedicated significant space to providing member firms that have a nexus to crypto with guidance on crypto-related communication specifically, and through enforcement actions and otherwise guidance on what not to do in that space, and also more broadly with retail communications generally in the new age, in the 2025 news cycles, where we have a brokerage firm, which has an advisory arm, which has an investment news arm, which has a social media apparatus, and they may or may not follow on the same, and a crypto arm that they may or may not follow under the same umbrella. So the guidance is there, and to break it down for you a little bit, FINRA's expectations regarding communications touching on the crypto space, you can expect, have to come with disclaimers. Whether you have it in the text, you have it up front, you have it on a link, you have it in there, you have it as a read over, you have it on the bottom, you're going to need the traditional disclaimers about crypto. Inherently, even today, whether it's a security or not a security, and whether it's governed by FINRA or not, is often turns on whether it's a security or not a security. So be brushed up on the specific digital asset we're talking about. And that is actually a compliance pointer. Be brushed up on the specific type of digital asset you're speaking about to determine whether this rule set governs. Because if it's a security, or if you're speaking about it in a member firm capacity under FINRA, then you need to provide a fair and balanced assessment of the risks of the digital asset or the crypto involved, including that it's probably speculative in nature, that has significant volatility, the lack of SIPC protection, even if it's held within a qualified crypto custodian or in cash, and the inherent fraud risks of crypto, however your organization wants to phrase that. You're going to need those disclosures in every communication involving crypto, whether it's a commercial or, again, a news article about crypto that comes from a member firm's affiliated arm. And importantly, in the same vein, remember that apparatus and the hub and spoke of the new 2025 style and financial services or investment services firm. The firm should really designate who's speaking in this communication. Is this from the advisory side? Is this the broker-dealer side? Or is this something altogether different that's really in a crypto management or on the crypto news side. Clarify whether it's a third-party offering, what services are being offered. And when you say you broker, you can buy and sell crypto, but you can also learn more about something else and get advice from a qualified professional. Differentiate who you're speaking on behalf of, what capacity they're working in, and what organization they're with, and who governs them. So if you're going to present to the customer an easy-to-use one-stop shop, you need to be very clear on what services you're offering, what type of FINRA-regulated conduct you're offering, and whether they differ, and be hyper clear on that. And we've seen through enforcement actions as recently as June 2025 that firms have been dinged for that. Too fast and loose with who's providing the services, who's doing what, and just offering customers a one-stop shop does not suffice under FINRA rules and or under SEC rules. That's really with respect to crypto specifically. And then with respect to more broadly, but equally as applicable to crypto communications, anytime you're communicating with retail in any one of these communications, FINRA in its 2025 guidelines made sure that even in the mobile applications, those apps, you open it up and there's news source, or even with respect to social media posts, if there is anything looking like a communication to customers about promotional information or something substantive, you're going to need to have accurate and disclosure of all risks and material informations. That clever tweet, you could have it, or X post, you could have it there, but if it touches on anything that looks like promotional information or something substantive, you're going to need to have a link. You're going to need to have a disclosure on there. And that also goes for what's more 2025 than influencer campaigns. To the extent that they're tied to a member firm, they're regulated. It counts, whether it's your favorite 7'4" basketball player saying it or a multi-Super Bowl winning football player saying it. It counts, and it is a communication that is governed by FINRA. It's governed by the supervisory rules and all of the regulations and rules involved. So that was from FINRA this year. We know it's evolving, and we know that each of these segments of digital assets, social media, and the integrated services providers need to take heed and be careful. Disclosure, and delineation are your friends.
Yeah, I could just, if I would just add in, you sort of bifurcated a little bit or distinguished between crypto asset securities and then other digital assets or other crypto assets. One thing I think is, is out there is that, from FINRA's perspective, maybe retail communications about crypto assets, whether it's a security or not, there's the specific communications rule, but then you have your 2010 obligations to, be engaging fairly with, your customers and those who you're interacting with. And, something I noticed that was pretty common in the exam priorities report were issues with potentially misleading statements and, arguably deceptive, descriptions of assets, maybe overly promising that they are a security, right? Rich, as you alluded to, that would get your SIPC protection, or, comparing them favorably against other types of products. So those are also, issues that are, underlying in the background. Being, fair and honest, something you need to do. And whether you're going to get your 7-foot tall basketball star to read the disclaimer for you or not, you do have to have the disclaimers, and you probably want to, avoid, where possible, sort of really, not carefully analyzed, not carefully thought through campaigns that are drawing these comparisons or suggesting that different types of assets, have certain performance perks or equate to your more traditional, securities assets.
Look, those are fascinating topics, and I think that this is a topic where institutions would need to pay particular attention to both the method by which they are delivering that service. There's lots of institutions that have not gone fully in R&D and coming up with their own products, but they are partnering. And we're going to talk a little bit later about third-party providers and the due diligence that has to happen there. But I think a lot more due diligence should be done on the front end so that you can adequately describe the risks that are attendant to these types of investments.
I think, Mark, we have a limited data set so far. I mean, we're I don't know if we're peaking, we're middle, we're early, but we are in the midst of a crypto cycle, and the last one was a few years ago. And it's when the cycle's down, it's when the cycles turn down or downturn, that really the enforcement actions, the customer loss, if at all, you know, if and when they occur, it's during those cycles. And we had some guidance on custody. We had a little bit of clarity, even with the regime change and a regulatory shift in the meantime, since the last downturn. But we have seen more crypto IPOs in the last couple of months than we had in the whole prior cycle. We see more of these digital asset treasury strategies amassing. We know that crypto ETFs have had regulatory arbitrage or obstacles removed. And we also know that as member firms get into digital assets more and more, it's just a numbers game, not all, but many more will. We're going to have the edge cases, we're going to have the test cases, and we're going to learn more on where the lines are and where the pitfalls are in failing to disclose, because these full service firms offering advisory, crypto, and brokerage services are becoming more prevalent. And we're going to learn more about the examples of what not to do. And there's going to be increased scrutiny. This is the beginning, 2025, really, probably, of this new wave of financial institution. And we'll learn more. And we're, you know, as they say, watch this space.
Right. And it's worth remembering, because this is so new, and the arc of regulatory and enforcement involvement is long, right? There might be activities. This is an area you mentioned, being thoughtful about all the ways that institutions are promoting or advertising these dollars, and sometimes using celebrities, banner advertising that will click through to something else, that the regulator has held people to account for that, to the tune of, you know, millions of dollars in fines, and holding the institutions who were willing to host that responsible as well, and not just anti-touting generally, but any statement that might be an overstatement had been found to be material and therefore misleading to the investing public. And so, you know, more to come on that. But I think that if there are institutions that are using platforms as part of their promotion or click through to get to these particular assets, they need to be thoughtful, not only about their own environment, but where that particular investor or customer is landing, because we've certainly seen the regulator reach through to those. So we talked a little bit about leading up to issues attendant to institutions that might be duly registered. So let's talk a little bit about issues specific to dual registrant issues with registered investment advisors. Rich, you want to take a stab at that?
Yeah, sure. I mean, this has become the de rigueur model for investment advisory or financial product offerings. I did a little digging through my trusty local LLM, large language model, and I checked the sources, 2 different sources. And I was interested to see if my anecdata actually matched the big data, that this is a prevalent construct, the dual registrant. And interestingly enough, there has been a decline in duly registered firms from 640 in 2020 to 409 in 2024, a 36% decline. So I said, oh, that's counter to what I thought. But then I checked that duly registered individuals have actually increased by 7% over the same span, from 300,000 to 320,000. So more people are duly registered, even though the firms have decreased significantly. Upon reflection, maybe my hypothesis was right, that there are more. This is more prevalent. But what we're seeing is consolidation in the industry. We're seeing fewer firms doing more of that work via asset under management, dollars at issue, more boots on the ground, 7% more, but it's been consolidated to larger players or for whatever reason, whether they're roll-ups or just closing down, taking down the shingle because the regulatory overhang has been too much potentially. We do know that having economies of scale help because you're going to need to have, unfortunately, robust compliance practices and protocols in place for both sets of rules. You're duly registered. You want to have your cake and get assets under management and paid by the slice. You're going to have to follow both sets of rules, and you're going to have to really double check that you have a culture of compliance meeting both sets of rules.
Well, I'm happy to hear, Rich, that your numbers came out somewhat close to mine. So there is probably less hallucination
good.
in the search models that we are using. To kind of put that in context, my research suggests that there are about 15% of FINRA registered broker dealers that are jointly registered, and this is through 2024, that are joint registrants. Many of those you that are on the phone may know that at the registered investment advisor representative level, that those individuals are only registered with the states and not with the SEC. So it sounds like maybe there is just as much activity, and it just shifts to different institutions. So if you are a firm that is responsible for keeping tabs on where those individuals go and how the disclosure around and risks attendant to dual registration have to be both explained to the investing public and adequately addressed in policies and procedures, what are some recent issues that you've seen that may be a canary in the coal mine for those who operate those types of institutions?
Brian and I worked on a matter that bore on one of these issues. Brian, I don't know if you want to take the mic.
Sure. Yeah. No. Happy to. The issue there was basically, again, it's around disclosure of the compensation, the commissions, the fee on AUM, who's getting what, and where is that being conveyed to the ultimate customer. And I think, without getting into the nuts and bolts of that matter, the issue there was that, there's a little bit of a silo effect, notwithstanding that it's all happening within one enterprise. There's maybe as a result of the consolidation happening so rapidly, there's the advisory side is not exactly speaking with the broker side, and you don't get accurate or fulsome disclosure of the types of compensation issues that I'm touching on, or other conflict of interest issues that, again, if they're disclosed, it's not fine, but it can be okay to proceed. And if you have the silo effect, you're not capturing, you're not really fulfilling your obligation to have that compliance program in place that's reasonably designed to avoid violations and to comply with the rules. So again, and that's an example that leads back to what we were saying earlier, right? Around conflicts of interest and compensation issues, commission splitting, things like that.
Yeah, delineation and disclosure of the commission and being upfront and letting the client know that we are duly registered for a reason, really. Mm-hmm. And it's okay to collect for doing this and doing that for different affiliates, as long as it's disclosed and as long as the sum total is not deleterious to the customer. That's okay. You can do that. You need to disclose it. But that's in the disclosure. And now, hearkening back to what I led with Reg BI, you need to run the analysis that this client getting into a program like this and maybe paying both fees makes sense for the client. It has to. It may, but you have to run the analysis that it does make sense for the client. And because you can be paid for as a firm that has a dual registration, you could be paid in different manners and collect compensation in different manners for different buckets or different accounts under different rule sets, whether it's assets under management, you get a percent, or you're charged on a transaction by transaction basis. It needs to be clear what capacity that the customer is being serviced in. And it also needs to be clear that there's not a conflict of interest, again, whether they're putting funds in one account versus the other, or whether they're doing whether a transaction is being entered into where you have multiple sets of payees, that there cannot be a conflict of interest in each particular transaction because the potential for conflicts of interest is high. We've seen examples, and there are a couple of perfect in a nutshell examples of this that FINRA has taken action on recently. But that's the main point, and what FINRA has also disclosed is the high risk for potential for conflict of interest. And the fact that certain firms or affiliates can earn a higher fee, that's okay. But again, it has to make sense for the customer and need to document that.
I guess in highlighting that, the disclosure and the differential, has to make sense for the customer brings to my mind, an interesting point that seems to reappear in the SEC's risk and guidance alerts that at least in the last decade or so, they'll always go out of their way to say that some conflicts cannot be disclosed by describing the language. And so there are there's some relationships and some amounts that an institution could be earning that the regulators could find are so beyond the pale that it doesn't matter. And we're not just really talking about the adequacy of disclosure, but as Rich mentioned, the unfairness to investors. So you want to be thoughtful about how you as an institution are analyzing the potential of a conflict in the dual registration relationship, and whether that risk to the investing public can be satisfied. And it should be something that is right at the top of the checklist for your annual reviews, and reviewing whether or not the procedure to surveil for that activity is sufficient. Has your institution grown? Has there been a merger? Are there any changes in the types of assets that are offered or sold to one side or the other? That would represent a need for a change. Is there a process for elevating particular types of sales of products to supervisors for particular approvals? Do they require any separate and prominent disclosures? Are they going to be mailed out to the customers? Are they pop-ups on some platform if individuals are engaged in that way? Are there surveillance features that will create pop-ups or alerts so that those types of issues can be elevated to compliance before? And these all become important because at the end of the year, when the individuals who are responsible for doing the annual reviews they need to ensure that the books and records are fairly reflect that those things have been done. The examples are legion of institutions that are under the regulatory scrutiny, and they're sitting across from the regulator saying, oh, we do this every year to protect investors and making sure that we're compliant, but the books and records that they might have to demonstrate that are lacking or underwhelming. And so it takes a little more time to think about what changes may need to occur to satisfy that in every year, but also think about the books and records, particularly in the dual registration scenario, so that you can prove that the good work that you were doing to making sure that your institutions are compliant can be supported.
If I may, Mark, just a tiny nugget there. You mentioned the possibility for separate disclosures, right? And I would just, one caution, lesson learned, that's not always a good idea and can lead to confusion, for depending on certain scenarios and who the customers are maybe. And, from our experience, at least, that was suggested as potentially being part of the problem, is that you had 2 or 3 different pieces of paper and it was unclear who was speaking on which piece of paper and how you should synthesize as the customer together what is being written there about what the fees are, what the commissions may be, when they apply, how they add up, is there any netting that occurs, things like that. So, separate disclosure, I think, is a great idea if you're careful about it. And you want to make sure that those separate disclosures are all in a line and can be understood together from the perspective of the customer.
They can't look like 3 of the same or 2 of the same disclosure, a dupe, right? And earlier when I said you need to be careful of disclosing, and I agree with you, Brian and Mark, I think we all agree. But there's a way to thread the needle, I think. You can do that if you are crystal clear in what capacity this form is being filled out, what it's for which services, with which institution. And you could even put in Mark mentioned, you're going to have to take special care if you're one of these dual registrants. You're probably going to have a section in there about put on every piece of paper what capacity you're operating under. That's a good specific section in your WSPs for everybody to abide by, so that you don't run into the issue of confusion. Who's collecting what? Who am I even, being disclosed or warned by? Who am I engaging or signing on the dotted line with?
So, Brian, I think I'm familiar with the example you were remembering. Could you explain a little more whether or not the regulator's problem was that the 2 pieces of paper, one ostensibly an additional disclosure, was inconsistent with the other, or whether they created confusion about the source only?
Yeah, no. So it's sort of twofold on the confusion, both in terms of the source, but then the way that, and I'm trying to be a little cautious here, the way that the sort of fee structure was disclosed, it at least gave the suggestion that they could either be added together, resulting in a higher charge to the customer, or you only were subject to one of them, depending again on who you were really basically doing the business with, which gets back to the, which capacity are you speaking in? So it's this, at least what came to mind for me, is the confusion angle. And, even, the regulator is standing there saying, do we add these up? Do we net them? Is only one of them applicable? And having to go through the process of explaining that, and then doing that, writ large for hundreds and hundreds of customers. What were you doing in each particular case? And obviously could have been avoided with a very carefully crafted and thought through set of disclosures that explained, whatever it was the client is trying to accomplish.
Well, this is a perfect lead in really to my next topic, which is compliance and outsourcing compliance. We probably have participants on the call here today that run the gamut, from institutions that may have large and well-established compliance to those that use various services and functions to satisfy their regulatory compliance obligations. And so there are particular risks that are attendant to outsourcing your compliance. It's probably been close to 10 years now when the applications for investment advisors began to ask a specific question: do you outsource your chief compliance officer? Who is that individual? That would give the regulator some insight into that area. There are lots of issues that are kind of attendant to this, but what are some of the key risks that are associated with outsourcing compliance functions for broker dealers specifically? Brian, you want to take that?
Yeah, I mean, I think first of all, this is an easy one to check off, right? The supervisory responsibility, outsourced, whatever function is outsourced or not, remains with the broker dealer. I think FINRA is persistently clear on that every year. They want to make sure people understand that. So a risk is thinking that it's sort of like a set it and forget it. I hope no one is in that mindset here, but it's certainly something that happens, and you want to avoid that. I also think, I was looking through some recent FINRA publications, and cyber security risk and operational risk exposure is paramount, and it's something that the regulators are very focused on in the modern era. Right, we already know there's lots of different types of cyber regulations, but understanding now, from a due diligence perspective, when you're signing up whatever, vendor and compliance function at a third party, understanding what they are doing to, secure their data, secure the data that you, the broker dealer, are, potentially sharing with them, or at least allowing to flow through them, right? And in particular around customer data, because, paired with the advent of cyber security related regulation is, there's an ever growing world of privacy regulation and customer privacy, personally identifiable information, and making sure that that's protected. So I think that's another area for risk. It certainly needs to be baked into any initial due diligence that the broker is going to be doing with a potential third party, and it should be part of ongoing due diligence, right? Testing, ensuring that your vendors both have policies and procedures in place to address it, but that they're actually, implementing those policies and procedures. And another risk area that I think is related to that is vendors, well, broker dealers themselves, right? And then their vendors may be using AI tools, right? Which may or may not be open source, may or may not train on data inputs. And that is another area where, again, you're running potentially headlong into these privacy considerations. So just understanding, it's not to say don't use it, but be cautious, understand at the due diligence phase, what is being used, how is the data protected, is it guarded off from, being trained on by the AI system, or is it going to find its way baked into the system going forward, and now everyone has your customer information? So those are some of the top level risks that I think are, first and foremost, regulatory concern in 2025 on outsourcing.
I have just a more fundamental one, maybe an obvious one, but it doesn't go without saying. Brian mentioned siloing earlier. If you have an offsite compliance function, they may not be minding the store. Things are still happening likely within the four walls of your business. Whoever remains in charge and signs on the dotted line, because you cannot outsource responsibility. You need to have your eyes and ears open. You need to have your door open to hear on a supervisory level and to see what's going on. And something we haven't mentioned, we're 40 some odd minutes in, we haven't said the word off-channel communications once. If you are in this industry, it's 2025, and we don't talk about this as much, but we did for the last 3 or 4 years. However, for example, if you see ongoing, on-site, off-channel communications, that may not be something that your exotic foreign compliance professional or outfit would have any business to know. You need to demonstrate that you are also keeping tabs on the compliance professional and the outsourced party, having built-in audit checks, performance checks, have a key performance metric, not be how many things did we get away with, but have some sort of performance metric showing that you are really empowering and hiring a compliance professional for results, not just to check the box. Show your diligence up front, like Brian said, show that you have spot checks, build it into the written supervisory procedures, that you remain in charge and they are assisting you with the supervisory function and the compliance function there. Mark, you seem like you want to say something. This is totally your world.
No, I think that we are so early in this discussion about how AI is used at the institutions that we can't even really comprehend all the ways in which it may be an issue for regulators. We have seen some analysis early on about institutions using AI to simply draft. And so if that's going to be anything that is retail facing or customer facing, it kind of goes without saying that there needs to be a lot of scrutiny around that. There was a related question, I think, that came up, at least it's related to me, for either of you, whether you have an opinion on whether and potentially when FINRA Rule 2210 will be revised to align more closely with the SEC's marketing rule, particularly around the bright line projection prohibition. So I'd open that up to either of you.
Just like we sometimes need to make sure that the compliance people are complying, maybe we can moderate the moderator. Tea leaf reader. You have your, really, in all seriousness, you have your ear to the ground on such matters. Do you, because it's really prognostication and hearing where the industry's going. What do you think, if you don't mind me flipping it back on you?
Sure. So for those of you who may not deal in this every day, you've probably now fully baked in what we were referring to as the new marketing rule, which essentially was updating a number of things, including providing disclosure around performance. And one of those amendments was a forward-looking, and here it was referred to projections. And so looking forward, one of the main impacts, I think, of the rule was really to allow for projected performance as long as if it was a product that already existed, that it be balanced with prior historical performance in ways that were not going to be misleading to the customer. A bright line projection prohibition is the suggestion that the prognostication not happen at all. I thought that there was going into the early to middle part of this year more conversation about it. I understand by reading the minutes of a recent FINRA meeting that it was not at the top of the agenda. I think industry would very much like to have a unified rule of the road in this instance. Some things ebb and flow, I think, with what happens in administrations, but I would expect this type of call for having a single rule, or at least one that more closely aligns with the SEC marketing rule, to be an issue that will not go away. So,
thanks, Mark.
Sure.
Back to you.
Yeah. So let's move on. I may not spend too much time on it, but I think the fate of the PCAOB has been very much in the news. And as a lot of folks know, there was legislation proposed in Congress to, I don't know, evaporate the PCAOB, shoot it off into space, absorb it into other agencies, cut budget, all the things that could befall them. And so where does that fight currently stand? Brian, you want to take the lead on that?
Sure, I'll do my best. I think, first and foremost, right, they survived the legislative effort. That is, that did not get through. I think, there's a new acting chair as of the end of July. That certainly is going to bring a different perspective to the agency, and I think a perspective that is, for better or worse, consistent, I think, with maybe the sort of the theme of that legislative drive to, shrink and reduce the role of the PCAOB. One thing I think is interesting, and it's not clear to me how this is shaking out yet with that new leadership, is at the end of 2024, broker dealers were sort of supposed to be a big priority from an inspection standpoint, and it's not entirely clear to me that that's going to remain the case. Under the new guard, I'm not sure whether we have seen, certainly the inspections are underway throughout the year, but whether we have seen the uptick that was sort of projected by those inspection priorities, again, at the end of the last administration. So, that to me, it remains to be seen whether that priority is there. But there seems to still be at least some appetite to bring, into sharper focus how the auditing of broker dealers is done, and then the oversight that the PCAOB exercises over those auditors. So that's out there. Again, and whether that fits into the budget, that seems to be something that Congress holds the purse strings on that, and if they don't like it, which they may not, then it's going to slow down for sure. But Mark, I'd be curious if you have any sort of take on the new guard and where things could be pointed.
Yeah, sure. The interesting thing to me is that in response to this first announcement and then these iterative steps to do something to rein in, to curtail the scope of the PCAOB, was how vocal various parts of the industry were in defense of the existence of the PCAOB. Lots of op-eds and discussion about the important role that they operate in the marketplace. And while there is certainly an effort to remove prior echelon of leadership, including Erica Williams, who was removed or resigned before this acting person, was this idea of overhaul. And yet, according to the industry trade organization, that represents $5 trillion of investment in this related space. Lots of academics from across ideological spectrum and trade organizations have expressed some concern about this. In the effort to rein in government, make government smaller, common sense regulation, something that I think is often being lost in this particular conversation, is that the money doesn't come from Congress, right? And so if a solution is to move it into the SEC, for example, and the SEC is losing 15 to 20% of its budget, does it become some kind of unfunded mandate, or is there a better way to have some reform? So, jury's still out.
Well,
look, we're rounding the corner on that. Yeah, sure, Rich.
Yeah, I was going to say I don't know the genesis of it, but I think the shooting into the sun or space or dismantling of the PCAOB, was often mentioned. I'm not sure if it was in the Project 2025 or some other, regulatory overhaul think pieces. But FINRA was supposed to be, or contemplated to have the same fate, or to be on the same chopping block. But it appears, at least in the short term or medium term, that FINRA is not going anywhere, and its constitutionality to conduct hearings, at least in a certain manner that comports with due process, has been reaffirmed. So looks like FINRA's not going anywhere, even if the PCAOB may be curtailed or reimagined, and that's really relevant to this group, I believe.
Thanks, Rich. Yeah. So before we close out, we've been talking a lot about federal apparatus and changes in the regulatory environments from a federal perspective, but we certainly haven't talked about how the states may step in to fill some of this regulatory void. Rich, you have any final thoughts on that?
Yeah, they're not to be outdone these days. Even though we have a powerful federal government and their far-reaching apparatus and statutory reach and oversight, whether there's a void or not, and I don't mean to quibble with the way you tee that up, Mark, I'm not sure there's a void, but in any event, whether they're anticipating a void or just making themselves heard, the state regulatory organizations and apparatuses have been more active in recent vintage than we've seen amongst this group. We were comparing notes. We know that states that some of you wouldn't expect are being quite active, and not the usual suspects of New York, Massachusetts, and California. Texas and Florida have robust investor protection activity, and they've taken some new stances and new actions, and they've also had enforcement actions in the crypto space as well. That's been on the state level and not federally engineered or charged. And also the National Association of has also the conglomeration of states have also brought a consolidated action themselves recently for high commissions in penny stock trades of brokerages. So whether they're filling a void or not, they're active. They have their pet issues. They may supplement or they may target certain issues, but we can expect activity for sure as the federal political or regulatory apparatus comes into focus. The states are going to do what they do because it is an independent system, and if you touch on the states, they have jurisdiction over you.
Sure. I mean, I don't know if I call it a regulatory void. We know that there were lots of enforcement actions, for example, on the federal level that were kind of pulled back from the table. But you're right. We very often see NASA working groups that step in with a group of states to address some of these same issues. So, Brian, before we close out, if you have a crystal ball for our general counsels and chief compliance officers, what they should be thinking about for the next year or so, what would you have at the top of their list?
I mean, honestly, I think one thing I would suggest is sort of maybe a refresh on your WSPs and just take the time now. There does seem to be not a void, I agree, but a tiny slowdown, maybe, particularly at the federal level. Take that chance to get a breath of fresh air and review your WSPs, review how they're being implemented, your controls, what you're doing to make sure that your compliance programs are working, and add where things need to be added, address gaps that you identify, and get them back up to snuff, because the slowdown, if there is one, is not to be long, and things are going to tick right back up very soon.
And to supplement that, the topics we've talked about, if you're in digital assets or crypto, get specific, have WSPs specifically regarding that. Retail communications we touched on. If you are communications involve your affiliates or advisory services from other affiliates, disclose those, delineate those. And we didn't get into it much, but outside business activities, whether it's crypto or otherwise, it's been another focus. Brush up on your WSPs. Make sure that you are showing that you are keeping up with what FINRA is telling you are the goals and the priorities of 2025 and beyond.
Amazing. Great points, guys. Ernie, turn it back to you to close us out.
Yes, gentlemen, you are the best. Thank you all. Mark, Rich, and Brian, excellent presentation. You guys were fantastic. And look, we hope you never have a problem, everybody listening on this phone. But if you do, these are the three guys you should go to. And we have coverage across the country where we can assist you and we can help you. And you definitely should, reach out, even if you just have some questions, in addition to today's questions. They're ready for you at all times. So that concludes our coffee chat today. On behalf of Thompson, Hine, and our amazing panel, I want to thank everyone for joining us and hope you found the discussion informative and that you'll join us for future sessions. We're going to take a little respite from our coffee chats. Our next one will actually be on October 14th, where we'll be talking about government scrutiny in investment management. And we hope that you will join us. So look forward to the invitation in your inbox shortly. If you have any additional questions, as I said, please feel free to reach out to everybody. And thank you again for attending, and enjoy the rest of your day. Thanks again, everybody.
Thanks, Ernie.
Bye-bye.
All right, thanks, everyone.